Us to this story now. The CCMA is often the last resort for employees who are treated unfairly. But what happens when commissioners are corrupt? A full-time senior CCMA commissioner has been dismissed for soliciting a bribe from an employer. Now, aggrieved employees are worried that commissioners are being bought. Let's speak to Magalate Phala from Magalate Phala Legal Services to look at the role and responsibilities of commissioners. Mr. Phala, good morning and thank you very much for your time. You know, it's one thing to hear of allegations, but it's most certainly another when commissioners are actually found guilty of soliciting bribes. Workers will surely lose faith in the whole arbitration process. What do you make of this case?
Good morning and thank you for having me on your show. CCMA commissioners are appointed in terms of Section 117 of the Labour Relations Act, either on a part-time or full-time basis for a specified period. So now there is over and above all the regulations. There is what we call a code of conduct for commissioners. And in terms of this code of conduct, commissioners are required to, CCMA commissioners are required to act with integrity, honesty, and independence when they deal with all these labor matters, either through what we call conciliation or arbitration. Mm-hmm. So, yes, so in an event where, which was the case in this particular matter, which came from CCMA Pretoria offices, in such an event, and if a party becomes aware that there was a corrupt activity maybe committed by a commissioner in the manner that they conduct the proceedings. So there is a recourse in this regard. CCMA users, either it can be the employee, applicant party, or the employer. They may report such activities to the CCMA management, and if it's a corruption, and they can actually even lay a criminal case in this regard.
Now, Mr. Phala, this one is a very fascinating case. Apologies for interjecting, because I just wanted to bring in our viewers here to fully appreciate what exactly happened. You have a situation here where the commissioner decides to collude with the employer to assist the employer to reduce the compensation that they were due to pay to the employee. And now, in this instance, we'd all know that the commissioner must display complete neutrality or impartiality when executing his duties. But in that case, he went on to argue that in this instance, where he was found talking to the employer outside of the process, he said he was merely attempting to further conciliate the matter before an award was issued. Then the question is, what do the rules provide for? Would there be any instance where a commissioner outside of the process could contact an employer and say, we're dealing with the matter, perhaps let's have a chat outside of the usual forum?
No, that is totally against, or is totally in breach of the code of conduct for commissioners. The code of conduct is clear that commissioners, when they arbitrate matters, they are not allowed to have a casual conduct with either of the parties, with one party without the consent or the presence of the other party. So that is totally in breach of the code of conduct, and it was, and hence in this case, the contract of this commissioner was terminated, and even when he referred the matter for arbitration, he actually lost that arbitration because it was unconvincing that he will actually, in the manner that he conducted the other party, that his attempt in that regard was to was honest, and it was faced, with a view to try and conciliate the matter further. That is not allowed.
How prevalent is this conduct? How prevalent is it? How prevalent is this conduct? Because a number of employees that find themselves either being unfairly dismissed will honestly lose hope now, thinking that where you think you can get somebody to arbitrate your matter, you could easily find yourselves being the small guy challenging a big employer that could have money to bribe if they wanted to. So how prevalent is this kind of conduct?
I think it is just an isolated case. I don't think the conduct is prevalent, because CCMA has in place a very stringent processes, quality checks, and so forth. So, and I don't believe that there is high prevalence of this type of corrupt activities.
If we had to apologies, if we had to empower the viewer, an employee that's perhaps looking to embark or take this route of arbitration, what would be the key points to understand when bringing your matter to the CCMA, just to sort of manage your expectations?
Yes. At the CCMA, I think users or employees have to, or even the employers have to understand what is the role of the CCMA. That the CCMA is actually not a court of law. It is what we call a quasi-judicial. It is a dispute resolution forum which has been, formed in terms of the Labour Relations Act. And the mandate of the CCMA is actually to resolve disputes, to provide speedy resolution of labor disputes through conciliation, mediation, and arbitration. So, in an event where a party seeks to refer a matter to the CCMA, if it is an unfair dismissal dispute, such an employer must refer a dispute within 30 days from the date of dismissal. If it is an unfair labor practice, he or she must refer such a dispute within 90 days from the date on which an act or an unfair act of labor practice has been committed by the employer. And at the CCMA, the first thing that happens there, and also just to clarify that the CCMA, provides free services, and employees may be represented by union officials, or they may be represented by legal representatives or legal practitioners. And then the representation of legal practitioners is regulated in terms of Rule 25 of the CCMA rules. So meaning that such representation can only be granted through an application. So it is not automatic. So the matter will first be conciliated by a commissioner through a conciliation. And then if a conciliation fails, the employee may still refer such a dispute to an arbitration within a period of 90 days. So a commissioner, if the matter is unresolved, will issue a certificate of a non-resolution, which actually give an employee now a go-ahead to now go and apply for an arbitration.